Welcome everyone to this seminar on the Register of Overseas Entities. This is the second webinar we've run on this topic, given the importance and the recency of this introduction. I'm really glad today to have joining me a number of speakers who can really give us an awful lot of background on this, and also critically from a question and answer point of view, answer your queries on this and give us more depth where you have some concerns or any areas where you want further information. So we're joined this afternoon by Jacqueline Griffiths, who is for the renamed Department for Business and Trade. We also have Rachel Watts from Companies House, and David Cleesby and Angela Shaw from Land Registry. Now, as I said, this is a great opportunity not only to hear from our speakers today around this topic, but also to have your questions posed to them so we can get those kind of nuances out and get the clarity you'd like. So please do put your questions into the chat during the session, and we'll do our best to answer them towards the end as we have our Q&A session. So I say, please do get those questions into the chat, and I'll read them out at the appropriate time. But without further ado, what I'd like to do first of all is hand across to Jackie Griffiths from the Department for Business and Trade.
Good afternoon, everybody, and thank you for joining. I hope that you can hear me okay. I'm just going to give you a little bit of the background to the Register of Overseas Entities and a little bit about what we've done so far. I'm the policy lead for the Register, and I've been working on it for several years now, hoping and waiting for a parliamentary slot. So when we got one, with the speed that we did and whizzed through Parliament in the way that we did, it was quite a surprise. So the Register is a new requirement which requires overseas entities owning land in the UK to register their beneficial owners with Companies House. I imagine that you probably know some of this anyway, but I thought it might just be interesting for context and to set the scene for Rachel and David and Angela, who will speak to you later on, for the operational delivery of the Register. Why have we got it? Why did we want such a Register? The purpose of it is to increase transparency in land ownership, thereby reducing the risk of money laundering through property in the UK, which is an evidenced problem that we've experienced in the past. As I mentioned just now, the Register was expedited through Parliament this time last year and implemented at top speed. Rachel may talk a little bit about this because Companies House colleagues had to make superhuman efforts to get a Register up and running. And the Register opened for registrations less than 6 months after Royal assent of that Act on the 1st of August 2022. Because of the speed at which it was implemented, we had to make choices both about what secondary legislation was essential to get the Register up and running and what could be done later on, and also about system design. So we've worked very closely in what was formerly BEIS, now DBT, rolls off the tongue, doesn't it? Between BEIS, Companies House and the Land Registries about what to do and how to do it. And that has had some consequences, which I'm sure that we can talk about later on. So we have a new requirement for overseas entities to register their beneficial owners with Companies House. Who does that apply to? It applies to all legal entities registered in a jurisdiction that is not the UK. Since the 1st of January 1999 in England and Wales, and the 8th of December 2014 in Scotland, and from the 5th of September 2022 in Northern Ireland. So it is retrospective and includes all overseas entities within those parameters I've just given you, as well as new entities, not new entities, entities buying land in the UK for the first time since the 5th of September 2022. So what does that mean? So they have to register. How does it all work? What it means is that for overseas entities that are not in scope of the 6-month transitional period that we gave to existing entities, may not register a qualifying transaction, which in general terms is a purchase, a lease or a charge, unless they can provide the relevant land registry with an overseas entity ID, which is generated by registration at Companies House. Those entities that were required to register in the transitional period will need to provide that ID at any time that they then engage with in a so-called qualifying disposition, so something that's in scope that needs to be registered. Then they aren't required at the moment to provide that ID proactively to the land registries, but I imagine that many of them may wish to do so. So the register opened for registrations on the 1st of August with a 6-month transitional period for those entities that were still in scope. We believe that to be a base of something like, and this is about approximation, 31,500 to 32,000 overseas entities in scope of the transitional period. That number obviously changes on a daily basis as dispositions are made, but that is the sort of basis from which we can start. Rachel, I'm sure, will talk through some of the numbers just now, but when the transitional period ended on the 31st of January 23, we were actually very, very pleased with the compliance rate, because not only did we have, over 19,000 entities on the register, there was also, excuse me, a large number of entities in the Companies House pending who had applied to be registered before the deadline. In other words, who have complied. So we think that out of what we expect was roughly 32,000 entities, that's a pretty good hit rate for something that's quite complex and that was implemented so quickly. And we've done a huge amount of stakeholder engagement in order to raise awareness and to encourage registrations. And if any of you listening have been involved in that, we're very grateful for your help with all of that. So the transitional period has now ended. Therefore, those entities that were required to register in that period that have not done so are now in breach of the requirements. However, and again, Rachel may mention this in just a minute, we know that lots of entities have tried to comply in time. And where they weren't able to actually submit the application before midnight on the 31st of January, then we will continue to encourage compliance and encourage them to register. Our aim isn't to criminalize large numbers of entities, it's to encourage them to comply. They may have had challenges, including having the information they intend to submit verified. We know that has been challenging for some entities. They may have had challenges in gathering the information that they're required to gather. The requirements are quite complex. And if you've got a very intricate corporate structure, trying to get sort of to the root or to the top of that structure might be challenging. And where there's a trust involved with the overseas entity, that has also created some difficulties for entities in trying to gather information about the related trust. The speed of implementation, of course, caught many absolutely legitimate people out. So although we know that there are, quite a number of entities that haven't yet submitted an application to Companies House, we know that there'll be many, many genuine reasons why that might be the case. I won't say any more there about implementation, leaving that to Rachel and then on to our land registry colleagues. What I will finish off by saying sort of quite briefly is, so we've got a register. What are we in the centre, in the policy team at DBT doing now? I mentioned at the beginning that we had to make some tough decisions about what secondary legislation was essential to make first. And we made those choices and laid those SIs that were absolutely essential before the register went live. We've now got another series of a second tranche of statutory instruments to make, and those will be made in the coming months. Those are for sort of quite technical things, things like applications to the Secretary of State for consent to register a disposition that would otherwise be prohibited to be registered. That just rolls off the tongue, doesn't it? I can just hear you all repeating that after me. We've got some around Companies House ability to share data with public authorities, and we've got a couple more in the pipeline. As I say, those will be coming in the next couple of months. We're also already making some tweaks to the First Act via the Second Economic Crime Bill, which is currently in Parliament and about to start Lord's passage. And the tweaks that we're making to what isn't a very old Act relate to a couple of things. The first is where we've realised that something wasn't quite right with the Act, which has happened in some cases because of the speed at which it was introduced. Many tweaks were made to it the weekend before introduction, and we've realised that some of those had either unintended consequences or didn't quite work the way we planned. We're also going to be making a number of changes to ensure that the powers under the Act, which is called the Economic Crime, Transparency and Enforcement Act 2022, remain consistent with the mirror powers in the Companies Act, which apply to UK companies. So all along we have done our best to maintain that consistency, only deviating from the requirements on UK companies where it's necessary to achieve the policy objectives. So, for example, the powers that we currently have for the registrar to be able to remove or rectify information are being amended via the second bill. So is the power to enable applications for material to be protected, and that's because the mirror powers in the Companies Act are also changing as a result of that bill. We are also going to be making a couple of other tweaks, such as requiring overseas entities to provide Companies House with the title numbers of their land, and that will operate for those entities already registered at the time of their next update. We're making a fix to an error that we noticed almost immediately after the Act got royal assent last year, where in trying to capture information about trusts, we had inadvertently left off capturing corporate trustees. We fixed that with a statutory instrument before the register opened, but that wasn't as neat a fix as we would have liked, and we're fixing that properly via the second bill. And we're making other technical tweaks, such as setting a minimum age for managing officers, where those are reported by overseas entity. In line with the Companies Act minimum age for directors, you will have to be 16 before you can be registered as a managing officer on the register, or have the details of somebody above that age also registered. So they're all, quite technical things. For those of you who love this stuff as much as we do, you can have a look at the Economic Crime Corporate Transparency Bill online as it begins law's passage, and Part 3 will show you the row changes. The other thing that we're doing now is a lot of work with our delivery partners, that's Companies House and the 3 land registries, on how implementation has gone so far, any unintended consequences, and working particularly with Companies House, but also with others, on compliance as it relates to those entities that have as yet not made an effort to register. I'll leave Rachel to talk about that a little bit more, and I hope that sort of gives you a flavour of what has been quite a crazy year for all of us. We know that there's still quite a lot of work to do, so we're not resting on our laurels, and I'm sure that Rachel will tell you a little bit about that now. Thanks very much for listening, and very, very happy to answer any questions that you have.
Thanks, Jackie. The floor is yours, Rachel.
Thank you. Hi, everybody. It's a pretty dull day here in Cardiff. I'm looking forward to spring, though. My bulbs are starting to look like they're going to be beautiful this spring. So I just wanted to build a little bit on what Jackie has already covered. We obviously worked really, really closely with our colleagues in what was then the Department of Bays. And in between royal assent and the launch of our new service, we had to develop quite a lot of functionality to make that legislation into something that was a real live register. And so in that time, we developed an online digital registration service so that overseas entities could go in and provide all the information required online. And we developed the database that holds all of that register information. we've done a huge amount of work in what was a very short amount of time. Initially, our estimates was that this was going to take us 18 months to 2 years to develop. But by focusing very specifically on the registration aspects, we were able to pare that down quite dramatically. And in that time, we also had to recruit a whole team and train them in what was a very an absolutely brand new register, and to ensure that they were able to have the knowledge and the skills, which was for quite complex requirements. And in parallel, we developed lots of guidance, working really closely with our colleagues in BAYS. And as Jackie's already mentioned, we did lots and lots of stakeholder engagement and communications, because we were really, really conscious of the fact that this requirement might come out of the blue for lots of overseas entities. So we wanted to reach out to anybody that we could think of, really, that might have an interest in this register, or may be a representative of an overseas entity. And finally, we actually went live on the 1st of August 2022, which only seems like yesterday to me, given how quick we had to do it. And here we are, nearly 7 months later. As Jackie said, there were some significant challenges to overcome as part of this. The main pain points that overseas entities had to overcome, as well as becoming familiar with the requirements, they had to then gather all the information about their beneficial owners, and then also needed to engage the services of an independent UK agent to verify that information. And Jackie's talked about some of the examples which made that particularly complex. But from Companies House's perspective, we also wanted to make sure that we were supporting overseas entities and their representatives in overcoming some of those challenges. So as I said, we've updated the guidance. So we've kept our guidance. We kept iterating our guidance, and we kept iterating the service based on the feedback that we were getting from our users. And one of the most common queries we were getting was around the ability to find an independent UK agent to carry out the verification. But behind the scenes, we knew that actually there was lots of agents who are registering with us to be able to offer that service. And so we took the decision to register a list of those verifiers, which really did help then for overseas entities to be able to find somebody suitable for them, and to start the process for registering. And today I'm really happy to say that we've had over 26,000 entities that have registered with us, and I think that's a real success. It is in showing that the hard work to communicate, to get the requirements out there, and to work with overseas entities and their agents, I think that shows the strength of that effort. And it's a massive step forward in transparency, because obviously the information about overseas entities and who is actually behind them, who the beneficial owners are, is now out there. It is now open and free of charge, and free for anybody to access. So we're working really, really very closely with law enforcement who are making use of this brand new data. I think that's a real success in its own right. And just one small example of that is where we have shared all the trust information with HMRC, who is using that information to inform their tax activities. And as Jackie mentioned, we know that some overseas entities have struggled to comply because of some of the complexities. We have been very clear that we need those overseas entities to get in touch with us at the earliest opportunity. We know that some verifiers have got backlogs of applications sitting with them, which means that the numbers will continue to grow, and we will continue to work with those overseas entities who are showing clear intent to comply with the requirements. But we now move from an awareness phase into an enforcement phase, where we will be actively pursuing those who either have not registered or contacted us. And this might include issuing financial penalties and possibly even prosecution. But it also means that there will be restrictions in place on the property titles where the entities have not complied. So it is really very important that anyone transacting with an overseas entity needs to be aware of this fact. And it's fairly straightforward. You can go onto our register. As I say, it's openly available and free of charge, and you can check if a particular overseas entity is registered with us or not. And in future, once we get past the first year, you'll also be able to check that they have filed up to date with their annual update. And our records will clearly show where those overseas entities are not compliant. We can't stop there, so there's still more for us to do, and we're really very busy still developing the rest of the functionality so that overseas entities can update their records and they can apply to be removed ultimately. As well as that, we're also looking at the changes that Jackie talked about that's coming under the new reform legislation. I think that's about it for me, and I'll hand over to David and Angela from the Land Registry. And but in the meantime, I think if there are any questions for me personally, then I'm also very happy for you to get in touch directly. Thanks very much.
Thanks, Rachel. I think it's over to you, David. As was said there, please do keep your questions coming. Obviously, there are contact points as well, but please do put your questions in the Q&A. We'll get to them at the end. So, David, the floor is yours.
Thank you. Can you see me as well?
I can indeed, David.
Great, lovely, thank you. So with regard to HM Land Registry's role in this, and I should state before I really get into this, I am speaking for the Land Registry of England and Wales, pretty much mirrored by what's happening in Northern Ireland and Scotland, but with some technical difficulties. So I'm not speaking on behalf of them, just the England and Wales Land Registry. We issued our guidance in early days. We received some feedback from the members of the public and probably the likes of yourselves. We've tweaked that, but our public guidance is now out there for everyone to view. We're complying with the Act by putting restrictions on all qualifying titles. We're in the region of 95,000 qualifying titles that had restrictions placed on them or are pending going on. There's roughly 10,000 titles whose title have got prior applications, so obviously we couldn't jump ahead of those with these restrictions, but they are pending and they will appear. So you might see some titles out there without the restrictions on. One of two reasons. One is because they're in the pile of the 10,000, or we've not managed to identify them for one reason or another. Work continues within Land Registry to ensure that we have identified all the titles. As you all know, our register is some 150 years old, so it hasn't been as easy as it might have been to trawl through the register and identify titles, but the titles we got on there pretty much mirror the overseas company data that we publish. We didn't enter any restrictions, or the Act doesn't apply to prior 1st of January 1999 application titles because they in those days we didn't actually ask for country of incorporation, so we simply didn't have that level of information on the register. I think that will change as we go forward, because as Rachel said earlier, or I think Rachel or Jackie, the obligation will be on the overseas entity to declare the titles that they have an interest in when registering with Companies House. So we will be able to cross-check that, and I'm sure that that will be resolved in the future. But what I'm talking about here applies to post 1999. So that's where we are now. We're very conscious that we have a number of applications in our stocks which are being processed at the moment, which might well be the last title that an overseas entity has. So it's quite conceivable that an overseas entity sold their last title maybe a year ago. Solicitors can often sit on these for many, many months before they even arrive at Land Registry. And of course, if they're complex applications, then there might be prior applications or other reasons why it's still in our possession. We've been working really, really hard to clear all of those. We've been encouraging our customers also to highlight them and expedite those. But we are certainly moving through those. We are giving all those applications priorities. So if any of your clients are saying that the application is still with Land Registry, if we can, we will move it on. Obviously, many might be subject to other actions happening on that title, but we're really keen to hear from customers because we don't want to inconvenience anyone at all as a result of an application being in our possession. So applications are now being received from overseas entities or the agents of, with the Register of Overseas numbers with those applications. So those are now being recorded on the register. We processed quite a few of those. It seems to be going quite smoothly. There are still some applications arriving without Register of Overseas numbers on them, and those are having to be rejected. So as a reminder, if an overseas entity is acquiring land, then we need the Register of Overseas Entity number on the day the application is submitted. If they're disposing of property, then there needs to be a valid Register of Overseas Identity number on the day of the disposition, so the day of the transfer, the deed. So those are the actions that we're looking for when we receive applications now, and our caseworkers are checking back with Companies House to ensure not only is the number valid and current, but it was valid and current on those applicable dates when they need to be from our perspective. So I think that's probably all I want to say at this moment. I'm really happy in a minute to take questions, but can't stress enough, we're working really closely with Companies House, and we'll certainly be working very closely with Companies House when it comes to the enforcement, just to confirm that we haven't got an application for disposal pending in our backlogs that would otherwise mean that an overseas entity has no UK property. But that said, there are still obligations for the overseas entity. Even if they have disposed of their property, they do still need to register with Companies House. So they are non-compliant, but yeah, we are working very closely with Companies House to ensure that, that the story behind it is also known when any action is taken. So I think that's probably it from me, actually, Andrew, unless so I'm really happy now to form part of the panel and take questions.
That's great. Thanks, David. We do have one question already come in, but obviously we'll move on to Angela, then we can return and get those questions answered by the panel, as you say. So Angela, the floor is yours. Thank you, David.
Hello there. So all I was going to add is that I would encourage you all to have a look at our practice guide number 78 on gov.uk, as it does have all of the information that's required to be able to lodge an application, sets out the differences that David mentioned just then about if you have a new overseas entity becoming a proprietor, and the difference then between where you've got a current overseas entity disposing of property. And we do have an appendix which has lots of different scenarios, so you should be able to do a bit of a pick and mix and find the answer. If not, then contact us. And again, as David said, if there's an application pending with us that needs to be moved on, or you have a query with, then do please contact us and we will do our very best to help you. Thank you.
Thank you, Angela, and thanks to everyone, Jackie, Rachel, David as well, on your very complete presentations there in terms of this. Now, we have our first question from James, and I quote, "How will the title register restrictions affect a potential sale? Can HMRC Land Registry stop a sale going through where the overseas entity hasn't complied?"
So yeah, I can take this one if you like.
Yeah, thank you, Angela.
So the restriction won't stop a sale going through because, of course, the application will already have been completed, and it's the registration of the transfer, for example, that is the application that's made to us at Land Registry. So when you lodge your application, you may have noticed that lots of our prescribed forms, the application form AP1, the transfer form TR1, they've had the transferor, transferee and applicant panels updated, requesting the overseas entity ID. So where you've got a new overseas entity going on the register or a disposition by an overseas entity, we will be looking for that number. And if it's not there, as David said, we will have to reject, unfortunately. But again, have a little look at those scenarios in the practice guide that I have referred to, because they might help you.
Great, thanks very much. I had one question as well while we just wait to see any more come through, and it was merely because I think I've seen some comments in the press around this area around trusts, and I wonder perhaps you could clarify how this whole process works with trusts and the kind of nuances around that particular area.
I wonder if Jackie wants to cover the policy position on it, and then I can pick up on the how you go about registering.
Thank you.
Yep, that was, in fact, I had just unmuted to say exactly the same thing, Rachel. I didn't think as ever. So if I just go sort of backwards a bit as to what is in scope as regards trusts. When the bill entered Parliament on it was published on the 28th of February last year and introduced on the 29th, trusts were completely out of scope. The only way that trusts were engaged at all was that if a beneficial owner was a beneficial owner of the entity by reason of being a trustee, they had to tell us that they were a trustee, but they didn't have to provide any information about the trust. During passage, we were able to introduce amendments related to that, which we'd been working on before with HMRC colleagues, but hadn't had a chance to finish before we were, with no notice at all, introduced into Parliament. And what those mean is that if a trust holds some kind of an asset via an overseas entity, it will very often use a corporate trustee to help manage that entity. So the beneficial owner of the entity will often be a corporate trustee. And where that is the case, that they are a corporate trustee, then the overseas entity must also provide Companies House with details about the related trust. And by details, I mean all that you would expect: beneficiary, settlor, protector, all of those main roles associated with trust information. That information is held securely by Companies House and is currently not shareable with anybody except HMRC. It's not public, following sort of the general UK tradition of trust information not being made public, but it is available to HMRC and will be available to other law enforcement colleagues. And why do we want to do that? Why is it important? It's because if we didn't gather the information about the trust, then the trail where we do have, for two reasons, where we do have suspicion of wrongdoing, the trail kind of stops there, and we wouldn't otherwise be able to easily get details of the trust. But also, what we have done is opened up another valuable data source for HMRC, which I think Rachel may have alluded to when she spoke about some of the important information HMRC has received, which is a benefit both to them but also to the people who are providing it. So I hope that's kind of what you were asking, Andrew. But please come back if not. And Rachel, if you'd like to sort of come in about how you actually collect that and what it sort of how it comes in.
Thank you, Rachel. Yeah.
So as Jackie said, you know, the amendments to the legislation to require information about trusts was a very late amendment to the legislation. So that was something that we had not anticipated or impact assessed in any way. And so if you are familiar with often government digital services, have got a very particular look and feel to them, and our register is built along those principles. It's got the same look and feel, except when we get to the trust information, we had to come up with a bit of a different tack to that, because we just didn't have the time to build it in the more traditional way, given the complexity of the trust information. You know, the trust information can include a lot of information, and so you know, we had to find an alternative solution to that. So what we have developed as an interim option is a very whizzy Excel spreadsheet, which is part of the journey, but has got a bit of magic in it. So you fill out all the information in the spreadsheet offline. That can then be uploaded as data into the registration application when you submit it. That allows us then to access the information in the spreadsheet as proper data. We can interrogate it in the same way we do the rest of the application, and to store it in a suitable format so that we can share it later on with law enforcement. We have obviously it's been very successful, although it's, you know, it looks very different to the rest of our services. But we are now working through putting in place the more traditional screens to take out that spreadsheet. That's it for me.
Great, thanks very much. Well, that was certainly answered my question. I think that was very informative in terms of understanding that addition to the process, and indeed how you've implemented that to make sure that people can comply and capture that information. At this point, I don't have any more questions from the floor, which I think is a testament to the comprehensive nature of what you've told us this afternoon. So I don't see any more questions coming in. Just to obviously to remind all our viewers that this will be recorded and it will be available on our online academy within the next 2 to 3 days, so you'll be able to share it with colleagues as well as listen back to all the information that's been provided. But for today, it really just falls to me to thank Jacqueline, Rachel, David and Angela for such a comprehensive tour of this new concept of the Registry of Overseas Entities, and as I say, a testament to the comprehensive nature of their discussion means we don't have any more questions. So for today, thanks for attending, thanks for listening, and thanks again to our panel.
Thank you, Andrew, for asking us. Always